hope I learned something. I hope I learned something. I hope I learned something from the stormy seas, from the brightest days, from the darkest nights, from the sunny days. I hope you learned something. I hope you learned something. I hope you learned something from the stormy seas, from the brightest days, from the darkest nights, from the sunny
And hello. Oh, there we go. Gotta kill that or there's an echo. And hello and welcome back, everyone. This is AHNC, All Hat No Cattle. I'm Hat. And today we will be finishing up the Trisha Anderson, or Trisha B. Anderson, as she is sometimes called, a former head of the OLC for the FBI, and who was one of the chief legal officers involved in the mid-year exam investigation. She was at the top of the top. Unfortunately, we haven't gotten a lot of top-of-the-top bombshells from her. Not yet. I suspect, excuse me, that we will be seeing some in this next round of questioning when the Republicans take over, but that's more conjecture than actual knowledge. I just have a feeling. A couple points of housekeeping. 2 days ago, I was waxing nostalgic about the dot that goes over the top of a lowercase j. Like that dot. For some reason, I thought it had disappeared, that they were no longer using that. Completely and utterly incorrect on my part. Sorry about that. Second piece of housekeeping. Yesterday, I was talking about an FBI FISA scandal, where the FBI had obtained at least 100 false FISA warrants over the course of at least the last 4 years, or from 2012 to 2016. So 4 years, but not the last 4. Turns out I had that mixed up. That wasn't the scandal that happened. The scandal that I was actually talking about was where FBI contractors were using what's known as 702 searches, which are very broad search options available. And you can basically use the FISA database, that's where the FISA came in, the FISA database, to search anyone. And the number of things you can do with those searches is truly scary. I mean, frightening to the point of, let's shut the government down, scary. Luckily, it was discovered, and the head of the DOD at the time went to the department, went to the FISA court and said, hey, this is going on. We've turned off all their access, but a lot of information got out there, and we don't know what to do. FISA court didn't know what to do either, so no one's going to jail or anything. I guess it was just a loophole, if you want to call it that. I think it was blatant criminal behavior. But anyway, that's the scandal I was talking about. That an article by the ACLU is listed in yesterday's description along with a briefer description of how I had screwed up, much briefer. So if you want to look for that article, and I think you should, go to yesterday's description and open it up. Okay, enough comedy jokes. Let's get to what we're here for. Trisha Anderson's closed-door testimony before the House Judiciary Committee and the Government for Reform and Oversight Committee, or Oversight and Reform, I always get it wrong. This was on August 31st of 2018. This is now the second round of questioning for the Republicans. Excuse me. It's the second round of questioning for the Republicans after a very uneventful first round by the Democrats, which is always the case. And of course, the Republicans started, and theirs were detail-oriented, but not all that illuminating. But I think we're going to get to something, as I said. Okay, here we go. Wait a minute. Okay, I'm not. Wow, why did I lose track of the pages? Excuse me a second. Okay, that's wrong. I could have sworn I had the right page, but I was completely off. Oh gosh, what should I look for? Darn it. See, the computer reset last night without my wanting it to, and therefore I lost the page. And of course, I didn't write it down. Okay, well, this is close to where we need to be because this is the Republican questioning. No, Picasso knows it wasn't page 127. I checked there, and it turned out to be incorrect. So it had to have been earlier than that. I do apologize, folks. I don't mean to make your day longer than it needs to be. Of course, I started late anyway because OBS was having a problem with my system again. Okay, here we go. Here we go. Why didn't that recess show up? Here we are, page 106. Okay. So again, the Republicans are going on the record now with their next hour of questioning. We've got 10:12. Let's see how we do with this hour. Mr. Parmenter. Okay, let's go back on the record. The time is 1:06 p.m. And before I turn it over to my colleagues, I want to note one thing for the record, and it relates to something that was raised by our colleagues in the previous hour. Our understanding, based upon conversations with the Justice Department, was that the memos drafted by former Director Comey, which have been largely declassified, were fair game for congressional investigators to ask questions about. We think that the representations to the contrary, at least based upon our understanding from the Justice Department, are certainly inconsistent with those and are incorrect. And I just want the record to reflect we agree with our colleagues' assessment of that point and will be following up on it. And if you weren't here yesterday, the Democrats went to ask some questions about the memos that Comey had written after his meetings with Trump. Memos which have never been corroborated. And the counsel from the FBI would not allow Trisha Anderson to answer that question. The Democrats said, why not? They're declassified. They're in the news. And the FBI said, nope, we think that goes to the Mueller investigation. You can't ask about it then. And I was probably pretty hard on the Democrats for asking the questions, even though it turns out I shouldn't have been. If I was, I don't remember. Let's just assume. And the Republicans have pulled out as good a reasoning as the Democrats did for why it should be open to questioning. Let's see what Mr. Redacted have to say about it. Mr. Redacted is one of the FBI legal counsels that are there advising Trish Anderson. They're not her official counsel, however. Mr. Redacted, thank you for that. In reference to the prior objection that we raised, we have consulted with minority counsel and have agreed to permit the asking of a single question which we understand they intend to ask, but we appreciate you expressing the committee's position and, of course, will convey that back to our chain of command. Barber, thank you. Mr. Baker. Mr. Baker starts questioning. Before we start, our process sometimes lends itself to duplicity and scratchy legs. So I apologize in advance for some questions that probably touch upon things you may have answered or exactly what you may have answered. Or exactly what you may have answered. At the end of the last round, our colleagues from the minority staff had asked you a question about Mr. Comey's book, and you had indicated something to the effect there were parts of it or things in it that you thought were inaccurate. That is correct, says Anderson. Could you elaborate on what those parts were? I identified a couple of different inaccuracies when I read the book. There's only one that I remember sitting here today, though. And what is that? That pertains to a comment that he attributes in the IG report to me during the meeting that took place immediately preceding the October 28th letter that was sent to Congress, in which he stated something to the effect of that I had asked whether we should take into account that sending the letter might bring about the election of Donald Trump, and that was, to my memory and to my knowledge, not an accurate statement. Harrington, you clarified your views on that in the response to the IG? Anderson, that's correct. Harrington, and that's reflected in the IG report. Anderson, that's correct. Baker, would you clarify that for us? I said something to the effect of, and this is what's in the IG report, that I asked whether we should take into account the fact that it might affect the outcome of the election, especially given that we weren't certain what we had was material. In fact, it was unlikely that it would be material evidence, and given that whatever we would write about it in that letter, no matter how carefully, could and would likely be overread and overblown. Oh, that's a very good catch, Picasso knows. Yes, duplicity is deceitfulness. He definitely meant duplication. Very good catch. I read right past that. It was another rough night. So I'm kind of on autopilot right now. Things like that I should catch, though. But that's why I have the best executive producer in the business to keep that kind of stuff from going past us. Thank you again. Would likely be overread and overblown. So the discrepancy in Mr. Comey's book was that there was a specific candidate name that was attributed to you rather than, she interrupts, correct? Baker finishes, just somehow affecting the election. Anderson, correct. The other instances of inaccuracy that you don't specifically recall, do they relate to things that were attributed to you? No. Okay. Just other statements of, concerning the investigation. Baker, concerning the investigation. But you don't recall even in general terms what they related to? No. Okay. In your role, Mr. Breitenbach interrupts. I'm sorry, did you ever memorialize any of those concerns? No, I did not. See, that's this whole memorializing. So I remember when we called it taking notes. But, no. The language changes. In your role, this is Baker again, in your role as a Deputy Attorney General in national security law, you indicated earlier that the attorneys that were working for you that were directly involved in mid-year, were they also involved in the Russia case? Yes, they were. Were there additional employees that you supervised that were involved, or just the same two from mid-year that were involved in Russia? So for the relevant point of time, just the same two. I do have an additional attorney I did have an additional attorney who was embedded in the special counsel's office. And that's below the SCS level? Below the SCS level. That's correct. Okay? That's someone that's in the special counsel's office. Correct. Now, were they on the Russia case before it became special counsel? No. Okay? So it's an employee of yours at the time that was eventually on special counsel. Correct. Okay, so you had indicated earlier that, or it sounded to me like the attorneys that were working on mid-year were, providing a wide variety of legal advice. Would your office have any role in 137 or sources in opening or giving guidance whether a source should be continued, discontinued, opened in the first place? What role, if any, would the General Counsel's office play in anything related to confidential human sources? I am not aware of any role that we would play with respect to opening sources. Sources are primarily run and handled by the DI, and their validation process is handled by the DI, not by the Counterintelligence Division. So it seems extremely unlikely that any legal questions that might arise would come to my attorneys, but I don't know to a certainty that my lawyers never gave any advice on human source issues. When you say DI, you're referring to the Directorate of Intelligence? That's correct. Would your lawyers give advice as to closing a source? I don't know. It's possible that if there were concerns about a source that came up in connection with a particular investigation, that my lawyers could be involved in conversations within the Bureau about whether to continue that person as a source. Excuse me. Okay, Baker continues, but you're not aware of that in the instant cases that happened. I assume you're referring to Christopher Steele? Correct. I don't know whether my attorney, who worked on the matter, was involved or was not in the conversations, in the consideration of whether to close Mr. Steele as a source. Do you know of any other cases, anytime, anywhere, other cases that your office was involved in giving advice on any aspect of informant operations? When you say any aspect of informant operations, one of the things I like about Anderson, she does not let this broad language frame her questions. She wants specific definitions to this overly broad stuff. The Democrats tried to get away with overly broad questions. Anderson called them on it, made them shave it down, and then gave them an answer they didn't want to hear after she got it parsed to a proper segment of her knowledge. It's very nice, very nice. To repeat, when you say any aspect of information operations, and then back to Baker, of whether to open someone, whether someone's in compliance during the time that they're open, and if they're not in compliance, whether they should be discontinued, I'm not aware of any such instances. Our office might, and actually routinely, provide legal advice on investigative uses of sources overseas. For example, on double agent operations is a good example of a circumstance that might implicate legal considerations. But in terms of the types of bureaucratic issues that you're describing, those would typically be handled by the DI, and if there were any legal issues, by the lawyers supporting the DI. So it sounds like you mentioned double agent operations. It sounds like your office might give legal advice when an issue arose through an actual operational issue? Correct. Rather than opening or closing based on some administrative reason? Correct. Are you aware, in the course of your tenure with the FBI, of sources, it doesn't have to be in the cases we're talking about here, are you aware of sources that were closed before being reopened? Are you aware of sources that were closed being reopened and utilized in investigations? Threw a whole word in there. Answer: yes. So it's not unheard of for a source to be discontinued and then not respond. Certainly not. I saw references in documents that I read with some regularity to sources having been opened and closed over time. Excuse me. Question: do you recall any instances or circumstances where someone might be closed and then reopened? There are a lot of reasons why a source could be closed, including that they just simply weren't providing fruitful information. Sources can go off the radar, can drop out of contact for a while, or sources can present, questions that are concerning too, in terms of their willingness to be handled, their willingness to comply with instructions that the FBI has given them. There's just a whole host of different reasons. So the last point you made, their willingness to comply with instructions that the FBI has given them. If they're not willing, or they in fact don't comply with any of the instructions that the FBI would give them, that would be a reason for someone to be discontinued? It could be, yes. We would refer to that as a handling problem. Could someone be reopened for a handling problem if what they subsequently come to the Bureau with is potentially so significant or of interest that it outweighs whatever the potential handling problem was? I don't know the answer to that question. I don't know the answer. Towing the party line here, or actually not knowing the answer? Give her the benefit of the doubt. Would there be a process in place? If you don't know that, I'm assuming, but I don't know for sure that you could be administratively closed for, absent doing some criminal act, you could be administratively closed for the reasons you cited. It could not be following your handler's instructions. You would be, in my words, administratively closed. But I think, in theory, this is Baker, but I think in theory, there could be someone who's been closed that was, up to their closure, providing credible information that comes back to the FBI or any agency that, or its sources, and the information they come back with is potentially credible because they have a history of being credible, that they would be re-examined for potential use and possibly reopened. That's not out of the realm of possibility? I believe that's correct. So what is he getting at here? What I see him doing, and I'm sure it's been apparent to everyone well before this, is that he's making a case as to why the FBI didn't just reopen or reactivate Steele for the reporting that he was doing, as opposed to making Bruce Orr be their back channel for the information from Fusion GPS, which was both Christopher Steele, Glenn Simpson, I'm still asleep, folks, Glenn Simpson, and Nellie Orr. And perhaps even a little Natalia Veselnitskaya thrown in there. Why not do that? I think that's where they're getting at. Let's see. Question. I believe you were asked in the last half hour a question about media leaks. I have a very specific question about media leaks, and it's not about any. It's my understanding that the IG made reference to some media leak issues in the Bureau. I think very broadly there are a lot of unauthorized contacts. Are you aware of any unauthorized media contacts anybody had in OGC with media? No. Any OGC, sorry, I literally fell asleep in the middle of that word. Any OGC employees? No. Are you aware, or have you heard, this is the specific part that I referenced. I had just recently heard that there is some assertion that the Bureau would leak information about a case to the media for the purpose of having the media report out there, so an analyst checking public source information to try to verify a fact that they're trying to verify would see this news article or report that was really set in motion by a Bureau leak. Are you aware of anything like that ever happening? No. Then you haven't been paying attention, have you? Back to Baker. You had indicated earlier, you and I had a discussion about sometimes the tensions between prosecutors and investigators, FBI, DOJ, having a healthy outcome. Is it your opinion that attorneys assigned to the FBI's general counsel felt there was an atmosphere where they could be candid with their fellow attorneys, regardless of the rank of those other attorneys? Yes, generally speaking. Are there instances where in your branch that anybody ever expressed a feeling that they couldn't be candid or felt that their opinion would be outweighed by others? I'm not aware of any such circumstances. Are you aware of a survey that the FBI does, a climate survey? Yes. God, I haven't heard this brought up in ages. And what is a climate survey? It's a survey that's done that asks certain questions of all FBI employees that are designed to eliminate the FBI's performance on certain metrics. There are some questions that are geared at some of the performance of the FBI generally, and then others that are geared towards particular supervisors and executives within the FBI. And the result of these questions, or this survey, what is the goal of the answers to these various metrics? I don't recall the FBI's stated goal of doing this, but my general understanding was in order to inform the FBI leadership. Hate when their page breaks like that. Sentence breaks. In order to inform the FBI leadership about concerns within the workforce and in order to assess areas of improvement within the FBI. So it would go to things like employee morale, whether the rank and file, thought recognition, and awards were properly given out, that sort of thing. That's my understanding. And how, if you know, did the Office of the General Counsel fare in these climate surveys? It's hard to characterize in a general way the results of the survey, and I don't remember these specific results. Do you remember anything specifically about the National Security Branch? No, I mean, in the general sense, though, is that the lawyers are harsh critics, and they expect high performance from their executives, and so we had some of the more outspoken responders to that survey. Excuse me. Very dry today. It's a wet day outside, too. Weird. Was there any particular area that the outspoken people gravitated towards in expressing their thoughts? One of the areas that I remember there being some complaints about was the degree of communication from the General Counsel to the office generally. And the office being the branch? No, the Office of General Counsel. The whole Office of General Counsel? Yeah, okay. Parmenter steps in. I think in our first hour, we talked a little bit about where you had indicated that you had received a call from someone at the ICIG or ICIG Council when the Clinton email matter was referred to the FBI. Is that accurate? That's correct. There was a woman named Jeanette, and you didn't recall her last name. Correct. Did the break help to refresh your memory of her last name? No. Okay. Have you ever spoken to anyone else at ICIG with regards to the mid-year exam matter? Dude, mid-year exam investigation. Don't call it a matter. Okay. She says no. Okay. Charles McCullough was the ICIG, or perhaps still is the ICIG, at least when the mid-year exam matter was referred to the Bureau. Is that correct? That's my understanding. Did he ever brief you or anyone else at the FBI or DOJ or meet with you about that referral or about the facts of the case or anything like that? I never met with him, no. Are you aware whether anyone else met with him, whether in OGC or elsewhere in the Bureau? I don't know. Did you ever speak to him on a secure line or over the phone or anything like that? No. Maybe not meet with him? No. Are you aware whether anyone at the Bureau ever did? I don't know. Mr. Baker. I'll throw in random questions. Were you ever at a meeting or ever copied on an email from Peter Strzok where he is asking generally for any intelligence information on any Hill staffers, specifically a Senate Judiciary staffer named Amelia DeSanto? No. Okay, that's already been asked. Mr. Parmenter, you also talked maybe in the previous hour with our colleagues about the 793F statute, which we read yesterday, the topic of gross negligence and intent. Unless I'm correct, you had stated that, your belief was that the intent was not required, or was required rather, for a prosecution under 793F. Is that correct? Correct. Okay. And a plain reading of that statute, I believe 793F2, does require a showing of intent. 793F1 maybe does not. It just requires a gross negligence from someone who has national defense information. Is that your general understanding of the plain language of the statute? That's my recollection, yes. Okay, here we go. So, I guess, can you expand a little bit on what your opinion is, or what, the opinion of the General Counsel's office was on that issue of intent? So we are not the prosecutors, and so we obviously defer largely to the views of DOJ in the interpretation of criminal statutes under which they bring prosecution. But it was our understanding that in looking at the provision, number one, it had never been used before, and we're talking about F1, the gross negligence provision. Number two, there was some concern that was articulated in the legislative history that might apply to prosecutions in circumstances where there was an intent. And number three, there were some constitutional concerns that might have been created by a circumstance where the Justice Department might try to prosecute somebody where there was not evidence of intent. Breitenbach. On the constitutional vague issue that you just cited, I'll stipulate to you that we're aware that 793 was used as a predication to obtain legal process. So I'm wondering if the FBI, you in particular, knew that there were constitutional questions as to the continuing validity of that particular statute. Why would the particular agents obtaining legal process to have used in that statute as legal predication to a court in order to obtain evidence, whether it's a search warrant or other legal process? Folks, if I sound too bad here, too mushy mouth, let me know, and I'll just I'll take a break and I'll come back in an hour or two. I'll be able to finish this today, no problem, but I just don't want to make this sound like a mess. I've done it before, and I can do it again. So what I testified to a moment ago was that there might be constitutional concerns if there was a prosecution brought under that provision in a circumstance where there was not evidence of intent. Okay, my executive producer says, let's take a break. So that's what I'm going to do. I didn't think I was doing very well, and she confirmed that. So I'm going to pause the stream for, let's see, it's 10:38. I'm going to pause the stream for an hour. I will be back at 11:30. I'll put up a marker on YouTube to show that I'm coming back then, and I will not change the the format, whatever you want to call it, of the live stream, so that nothing will have been different. You'll be able to just click on and come right in, and the chat will still be there. So yeah, let's see you back here at 11:30.